You know, when you hear the term international law, it can sound, well, kind of dry, right? A world of dense treaties and super formal procedures. But what happens when you actually peel back the layers? You find these incredible human stories. And today, we're going to do just that. We're diving into some decades-old legal documents to uncover a real-life drama, how one brand new nation took on a global superpower in the world's highest court.
I mean, really think about that for a second. How do you even begin to sue a whole country? It sounds almost impossible, doesn't it? You can't just, send a strongly worded email to the prime minister. Well, it turns out there is a very formal process with very specific rules, and we're going to walk through it step by step.
Okay, so this isn't just some theoretical question. This really happened. Back in 1961, the Republic of Cameroon filed a case against the United Kingdom. And this entire incredibly complex process was kicked off by this, a simple letter to the International Court of Justice.
To really get a handle on how this all works, we're going to structure this explainer like a 5-act legal drama. First, we'll look at the core conflict, then we'll see how the case was officially filed. After that, we'll meet the legal teams, watch their procedural moves, and finally, uncover some really unexpected twists that popped up along the way. All right, Act 1. Every story needs a conflict, right? An inciting incident. In international law, they call that a dispute. So, what was the fundamental disagreement that brought these two nations to court in the first place? First up, let's be clear on our main characters. On one side, we have the plaintiff, the one bringing the case, the Republic of Cameroon, a nation that was newly independent at the time. And on the other side, the defendant, the United Kingdom, which was the former colonial power in charge of the territory they were arguing about. The heart of the matter is laid out right here in this quote from the initial filing. Cameroon's whole complaint was about how the UK had handled its job under a UN Trusteeship Agreement. So this wasn't a fight over a border or a trade deal, it was about something deeper, the duties a nation has when it's supposed to be looking after a territory for the whole world. So you've got your dispute. The next step is to make it official. This isn't a private argument anymore. It's a public matter that basically puts the entire world on notice. Let's see how that happens. And this is just a brilliant illustration of the process. And notice the speed. May 30th, Cameroon files its application. The very next day, the court's registrar, who's basically the chief administrator of the court, sends official notifications to the UK and to the Secretary General of the UN. Then the Secretary General has to tell every other member state. So in just a few days, a fight between two countries is officially a matter of global record. Now, a country can't argue a case by itself, right? It needs representatives, legal experts who can act on its behalf. And in the language of the International Court of Justice, these lead representatives have a special name. They're called agents. Let's see how this played out. Cameroon makes the first move. Through a formal letter and then a follow-up telegram, it officially names its ambassador to France, Monsieur Kuo Mukomari, as its agent. He is now the guy, the single point of contact responsible for fighting their case. And the UK's response comes just a week later. In a letter acknowledging they got the case, they tell the court that a Mr. F.A. Vallet has been appointed as their agent. And just like that, the legal teams are in place. The battle lines are drawn. Okay, so before the lawyers start making their big arguments, there's this really critical phase that most people don't even see. I like to call it the procedural dance. This is where the court and both countries negotiate the timeline and the rules for the whole written part of the case. Now, to follow this dance, you just need to know two key terms. The memorial is the plaintiff's opening move. Think of it as their detailed written argument. Then you have the counter-memorial. That's the defendant's chance to respond, to lay out their side of the story in writing. And believe me, the deadlines for these two documents are everything. Now, what's so fascinating here is you can see this strategy playing out. The court sets the first deadlines, but then Cameroon asks for an extension, citing great difficulties. The UK agrees, but there's a catch. Only if they get a similar extension too. Then, a few months later, it's the UK's turn to ask for more time. It's a formal negotiation, but you can see both sides trying to buy as much time as they possibly can. So, just when you think the path is all set, things start to get complicated. This case was full of these unexpected twists that actually tell us so much about how international law really works. We're talking about challenges to the court's power, powerful spectators, and even a new player on the judge's bench. In the very same letter where the UK appointed its agent, it included this one line that would completely change the direction of the case. It was a subtle but incredibly powerful legal move. And there it is. The UK wasn't just getting ready to argue the facts. They were getting ready to argue that the International Court of Justice didn't even have the right to hear the case at all. This is called a preliminary objection, and it forces the court to stop everything and decide on its own authority before it can even look at the main dispute.
But the UK wasn't the only other power paying attention. As the case was getting started, another global player quietly entered the scene, not as a participant, but as a very, very interested observer. Just look at this. The legal advisor for the U.S. State Department writes directly to the court, "The United States wants copies of everything, all the confidential filings." This tells you the case had major geopolitical importance. I mean, this is 1961, the peak of the Cold War, and the U.S. is watching very closely as these newly independent nations in Africa deal with their old European colonial powers. This isn't just a legal case, it's a political event.
And getting access isn't automatic. The court can't just hand over the documents. It has to follow a really strict procedure. First, it has to ask both parties what they think. The UK says no objection pretty quickly. Cameroon takes a few months, but eventually they also give their okay. It's only after both of the original countries agree that the court grants the US access. It's a really meticulous process.
The final twist didn't come from the lawyers, but it had to do with the makeup of the court itself. The judges at the ICJ come from all over the world, but in this specific case, one particular nationality was missing.
This is where a special rule of the court kicks in. If one country in a dispute has a judge of its nationality on the bench, the other country has the right to appoint a special temporary judge, called a judge ad hoc, to balance things out. See, there was a British judge on the court, but no Cameroonian judge, so Cameroon used its right to appoint one just for this case, to make sure its perspective was represented on the bench.
So, as we've seen through the lens of this one historical case, the whole process involves these very distinct roles. You've got the agents, who are the champions for their countries. You have the judges, including those special ad hoc judges, who hear the arguments and make the final decision. And you have the registrar and their staff, the absolutely crucial administrators who keep the whole complex machinery of international justice running.
So what this all shows us is that suing a country is this slow, methodical process of letters and deadlines and procedural rules, but it also brings up a much deeper question. That challenge from the UK, the one about the court's jurisdiction, it reminds us that in international law, even the authority of the referee can be questioned. And it leaves us wondering, when the rules of the game itself are in dispute, who really has the power to decide the outcome?